think what was really important was a couple of court decisions. One in 1925 where a kind of a hapless radical named Benjamin Gitlow was in New York, and he was, I guess, an anarchist. An anarchist wanted, against all government. And he was apparently urging overthrow of governments, convicted by New York courts, and he appealed on the basis that says Congress shall make no law, and why should I be convicted for? The Supreme Court said Mr. Gitlow was convicted. He was rightfully convicted, and he was still in jail 12, 15 years later. But then the courts was always assumed that the First Amendment was applicable to the states through the 14th Amendment. Say what? That right there, Justice Sanford suggested you can apply the First Amendment to the states. You can nationalize the First Amendment through the 14th Amendment. The 14th Amendment was adopted in 1868 to protect a newly freed slave population, and said in effect, no person shall be deprived of life, liberty, or property without due process of law. And either liberty or the idea of due process of law would seem to protect one's rights to speak and publish. So the First Amendment thus therefore could be applied to the states. And then in 1931, in the granddaddy of all First Amendment cases, Neer versus Minnesota, and the Supreme Court, by the narrowest of margins, a 5-4 vote, said that prior restraint is forbidden by the First Amendment, and that Minnesota can't have prior restraint because the First Amendment is applied to the states through the 14th Amendment. See Gitlow versus New York. That really completed the nationalization of the First Amendment. I still find that remarkable, but there's an enormous leap of faith made by Justice Sanford, and I'm not sure he had any law, any precedents he could draw on. Saying, oh, by the way, the First Amendment's now nationalized. He can't do that way as he can. He's on the Supreme Court, and he had a majority.